Without any further delay, let's move on now to the third panel of this session, which will be led by Ulrike Thiel. Ulrike is, as you will see right now, the Director IP and Frontier Technologies of WIPO. Ulrike, the floor is yours.
Good morning, everyone. As we move into panel 3, we widen the lens beyond Europe and look at a very fast evolving global picture. Generative AI is not only raising profound questions for copyright law within the EU, but globally. It has been the fastest ever adopted technology. ChatGPT had more than 100 million active users within less than 2 months of its being launched. And it is reshaping innovation and creative ecosystems around the world. As we've already heard from everyone speaking here, the questions are profound and they are complex. And the way forward is far from clear. Countries around the world are certainly exploring different paths. And I would like to remind Harry that Phileas Fogg had 70 days to go once around the world. Unfortunately, we have 30 minutes to try and do that this morning. So in this panel, what we thought we would do is we explore the international perspective by having a look at 3 jurisdictions: Korea, the United States, and India, and have a look at how they are navigating the transition that we're seeing. We will discuss not only their legal responses, but also structural questions, as we've seen in panel 2 just now. What does copyright infrastructure for the AI era in the global context look like? How can transparency, datasets, licensing, and output-related rules converge into workable solutions, workable practical solutions for creators, innovators, and citizens? So without further ado, because time is tight, let me introduce our fantastic panel and speakers. We have Ms. Choi, Deputy Director of the Korean Ministry for Culture, Sports and Tourism, who is joining us remotely. Ms. Lee Chitrik, University of Maryland and Duke University, and Mr. Ankit Sandhi, intellectual property lawyer from India. So I will, and that's worth an applause. So let me begin by having a look at Korea. Where is Should I go back to? I will go. So let me begin, now that you can hear me again, with Korea, where a remarkable multi-year AI copyright working group is actively shaping national policy. So Ms. Choi, joining us remotely, from your public sector perspective, Korea has developed several government-run working groups and guidebooks on GenAI and copyright since 2023, including concrete guidance on fair use and transparency. From your experience, what has been the most effective element of this government-led approach, and what still proves to be difficult in practice for rights holders and AI developers alike?
Thank you so much, Ms. Hill. And thank you so much for having me today. I'm so sorry that I couldn't join in person. It's my great pleasure, and congratulations to the launch of EU Corporate Knowledge Center. Regarding your first question, I think the most effective element of the government-led initiative is that the government government is in a position to resolve the information asymmetry between the rights holders and AI developers. So the government may publish a lot of guidelines. They can give a lot of educational and information programs. And also another important element or effective element is that government is actually in a position to tell the stakeholders, to tell the rights holders, the AI developers, saying that, hey, please come here and sit together and talk to each other. Because the government is supposed to be a very balanced entity, which does not weigh into any specific party. And the difficult things in practice for rights holders and AI developers is that when we talk to the rights holders, they say, hey, we need compensation. We need to be compensated for the use of our works. But the AI developers, they do not come to us. They do not approach us and talk to us. That's the most difficult part for the rights holders. And for the AI developers, they always say, you don't want to talk to the rights holders without any standardized price tables. So the AI developers, they actually want the government to develop a standard price tags or the tables. So that's in practice the most difficult case.
Thank you so much for that. And I mean, it's interesting. So the Korean working groups aim to bring together the rights holders and the AI developers to the table to negotiate data use and training, rather than simply relying on statutory solutions. I mean, clearly there have been efforts around the world to bring those two sides to the table. And I mean, my question is about the magic. Do you see this collaborative and cooperative approach model as scalable internationally? And what does it take for such negotiations to actually succeed?
Excellent question. Of course, I believe that it is scalable internationally, of course. But what I mean by scalable internationally is could be done in two ways. First, each jurisdiction could carry on their own government initiatives, and maybe there could be a global entity such as WIPO, which can provide such platforms. But the prerequisite of both approach is that there should be a technical system where rights holders and AI developers can access and do the negotiation and conclude an agreement. For example, in Korea, there's Corporate Business Support Center, where anybody can access and look for rights holders' information so that they can approach the rights holders to get some license. Also, the system provides completely online and automatic licensing function. So, for example, if you want to use a music, you can just click the music, and you can you can write the agreements, and then you click it, and it will go to the rights holders, and you can conclude the agreement. So, what the government is trying to do at the moment is that we would like to add one more tick box saying for the purpose of AI development. So that's the Korean government is trying to do, and I think the most important and very important elements for success of this is that the government needs to pinpoint two elements. First one is that the government needs to come and approach the companies or AI developers who want to join this scheme. So, for example, the Korean government recently contacted 150 software companies, which is the members of Korea Software Association. And among the 150 companies, 17 companies said, yes, we would like to do. So about 11% of those companies are actually would like to join this scheme. So that is really important. And another is that government also needs to pinpoint which area is most highly probable to succeed. And our opinion is that it could be legal or medical data parts because it's really important. And when we talk to people who have these data sets, they're very willing to make transaction with the AI developers.
Thank you so much. And maybe one last question, if I may, because clearly the AI industry and rights holders still differ very sharply in their expectations around AI and copyright. But it's really not the first time that tech, and many speakers have said it, that tech disruptions have challenged the balance, how we do things. So as we look at today's conversations and debates about AI and copyright, what can those debates teach us about how to prepare for the next technological disruption looking to the future?
Yes, this is a very, very tricky and difficult question, but the question that we should be able to answer. So as we witness the development of technology, it's getting faster. And so when the government is trying to stick to statutory solutions, it could be a little bit or far further slower than the market development. So I think I would like to recall what DDG Fobang, what she said in the keynote speech, that one fits all solution does not work anymore. So in order for the government to properly cope with the technological development, but at the same time, in order to protect the rights holders, we need to know how to provide the timely information to the policy customers. So we call it policy customers and stakeholders. So everyone who could be affected by government policy need to have the right information so that they can use that information to protect their rights and in order to develop the technology. I think we need to look at diverse directions and we don't need to stick to statutory solutions.
Thank you so much for that, and certainly as WIPO, I appreciate the call out for the international conversations. But let me turn from east to west to the United States. And Lee, the law in almost every jurisdiction around the world, or every jurisdiction around the world, is still catching up with the technology. And historically, when technological disruption challenges copyright and tells law, the law tends to evolve much, much slower than the technology. In contrast to Korea, as we just heard, where we have a government-facilitated approach, in the US currently, the approach is to rely heavily on the courts applying the fair use doctrine on a case-by-case basis. From your point of view, what are the advantages and disadvantages of leaving these questions to judicial developments?
Well, thank you, Ulrike, for the question, and thanks to the EU IPO office for inviting me here today. Just for a little bit of context, in the United States, we do not have a text and data mining exception to our copyright statute. Instead, we have a fair use exception. And the fair use exception directs courts to look to a variety of factors to determine whether or not the alleged infringement is permissible. The factors include looking at the nature and purpose of the use, including whether it's non-commercial, looking at the nature of the copyrighted work, the amount of the work used, and market impacts. So one of the advantages of the current approach in the United States of relying on the courts is that it gives the courts the opportunity to look at the case before it and to really make a decision that are focused on the facts. And through some of the work that I've done, both domestically as well as internationally, with different multilateral organizations, we've seen that the facts do vary across different cases. So I think that's definitely an advantage. I think some of the disadvantages are that litigation, particularly in the United States, can be very expensive and time-consuming. One of the results of that is that creates a lot of uncertainty. For example, we've recently had a couple cases in the United States involving generative AI and copyright, and you had two district court judges who had different reasoning in the cases, and it's going to take a while for other cases to work through, for that to go up through the appeals system. So it's uncertainty for all the stakeholders. And there also is the risk that the focus on litigation could detract from efforts to try to build common infrastructure and look forward instead of looking backward.
Thank you so much. And legal reform will certainly take time. But also, as Anna's panel just before told us, so will building technical infrastructure. So, from your perspective, Lee, what elements of infrastructure are most urgently needed to make copyright practically workable in an environment where AI models and their training and their outputs are constantly evolving?
Yeah, so I'm, based on work I've done domestically, internationally, I'm a big fan of building infrastructure. And I want to come back to a point that you made and your colleague, Sylvia Forbin, made, that when you look at the world globally, unsurprisingly, different jurisdictions have very different viewpoints on the copyright issues. So I think it's important to build an infrastructure that can work across all the different jurisdictions, recognizing that we all have different cultures and norms, are going to strike balances differently. I think it's also really important, and it's come up through the conversations, that when we build the infrastructure, we have to think about it broadly in terms of rights. You know, here we've been focused on copyrights, there are trademark rights, we've heard about the neighboring rights. I was at meetings last week in Paris, and privacy was a big issue, and a lot of times the same data can have intellectual property issues as well as privacy issues. And I think some of these infrastructure options give us opportunity to try to address some of those issues holistically. And I think some of the things that we need are, you know, better mechanisms to give rights holders more control over their work. You know, we have robot.txt. How can we build that out? Through my work, I've heard that a lot of rights holders don't necessarily want a straight opt-in, opt-out, but want to have conditional opt-in, opt-out. So building in that flexibility, building in more groundwork to reach resolution, to reach agreement, having standard license agreements, again, voluntary. In the US, we definitely have a much more deregulatory approach than there is in Europe. But if you have voluntary agreements, kind of like we have for Creative Commons, it provides more opportunity for people to reach agreements and to be able to do that faster, and sort of common techniques for how to remit payment in situations where that may be appropriate, for the transparency. And the beauty of building out the infrastructure is it's something that can work across jurisdictions, and each country can decide to what degree they want it to be mandatory and to what degree they'd like it to be voluntary.
Thank you so much. And I mean, much of the discussion that we've had in the last 2 days has been, unsurprisingly, on the input side of training data and copyright. But some speakers have already made the connection and started talking about the output side of things. And clearly, jurisdictions are also grappling on questions of AI-generated outputs. From a use perspective and from your perspective, how should lawmakers balance innovation with accountability? And again, what role might infrastructure solutions play in all of that?
Yeah, well, you know, in terms of balancing innovation and accountability, as I'm sure most of you know, President Trump released his AI action plan a few months ago. You know, accelerating innovation is very much a priority, but so is, you know, building the evaluation ecosystem, which falls under that pillar. And I think some of the things that we can do is, you know, we don't have yet reliable mechanisms for identifying AI-generated outputs, and thinking about, you know, how do we do that, both in terms of deciding whether or not it's entitled to IP protection, how to differentiate along the continuum, because, you know, to what degree has it been generated using AI versus the human input. So I think, you know, building out those mechanisms are important, and I think coming back to having standard technical tools will help, because I think that's an area where we can reach agreement, hopefully quickly around the globe, and that would then give different countries the ability to decide how much they want to make it mandatory. And I think it also helps with the accountability issue as well, because when you look at the AI ecosystem today, there are a lot of different players in the value chain. And, you know, one of the questions I think we all grapple with is who should be responsible for what. And if you can sort of break it down into technical standards, then it becomes easier to hold different organizations throughout the value chain accountable for different types of actions.
Thank you so much. And in about 20 minutes, we've made it from all the way from east to all the way to west. Julius Fogg, I think, would be proud. But let's go in the middle. We've seen two very different approaches from Korea and the United States. Our next speaker will offer yet another perspective, and this time from India. Ankit, how is the Indian copyright framework currently approaching AI-related questions, and where do you see the most significant pressure points emerging on your side of the globe?
Sure. Thank you, first of all, for the question. You know, I think it's important to understand what is India's starting point. We're dealing with the 1957 Copyright Act. It dates back to that generation with very few amendments over the course of time. The Act is essentially very author-centric, and it's technology agnostic. So the manner in which author has been defined is linked to the kind of works, but not the kind of technologies that have been used to create those works. So what happens as a result is there's a lot of friction when this legal system encounters questions with the advent of AI concerning AI-generated outputs, whether that's subject matter protection or not, with text and data mining or AI training, whether that amounts to infringement or not. And as a result, and before I come to the pressure points, a few more peculiar features of the Indian copyright system that would be relevant for us to understand this better are as follows, that we obviously also, like the US and unlike the UK, although much of the legislation is very inspired by the UK Act, but unlike the UK, it doesn't have an express call-out for text-to-data mining. And we don't follow, like the US, we don't follow a fair use system. We have something called fair dealing, and it's an exhaustive provision which contains a list of 27 exceptions. And good thing or bad thing, text and data mining doesn't expressly fit in any of the 27 exceptions which are there. With this, the third thing to take note of is the fact that Indian copyright law is very human effort centric. Therefore, there's a lot of emphasis on humans' contribution and how much is human contributed to. So we moved away from sweat of the brow to a modicum of creativity principle. So humans' contribution becomes very important. And there's a strong focus on moral rights. They've been made non-waivable, and they are author-centric, so that again links the human element back to it. In this context and in this background, there are four broad pressure points that I felt would be relevant to mention. The first is the most obvious question as to what happens with AI training, with text and data mining, how legal is it? And there is, as we speak, a major litigation going on the lines of litigation in other parts of the world, particularly Europe, US. It has been filed by a large news agency against OpenAI, and it's a sub judice matter. Unlike the Advocate General, I don't hold that kind of office or that authority. I'm a party, I'm representing a Federation of Publishers there, so I'm not at liberty to mention or express an opinion on what's going to happen. But what the court is examining there is a very interesting provision in the section that defines the scope of copyright in India. The language is as such, it says reproduction including storage. And much of the debate is around harmoniously interpreting, because on first glance, the words reproduction and storage are not synonymous with each other. So where arguments have been advanced, it has been suggested that storage needs to be seen if something is being stored with the objective of reproducing it later. The right holders are, of course, saying, regardless of whether it gets reproduced or it has been reproduced, if it's capable of reproducing it substantially, even if not verbatim, it is storage yet, and therefore it amounts to infringement. So that's the first pressure point that we're seeing. The second is on the issue of whether AI-generated output can be protected or not. We've had the Surius case, which I believe if there's some time left, we might talk about a bit later. But regardless, if not, India in the early internet era, the 1990s, the early 1990s, had a round of amendments that changed the definition of author. It wasn't quite a very substantial amendment, I must say, but it was substantial enough for the system to be changed and for the Copyright Office in India to actively receive and register applications concerning use of technology or computers. So because it was back in the 1990s, the word used is computer program. So what it says is, in case of computer-generated works, the author that causes the work to be generated can claim themselves to be the author of that work, thereby suggesting that such works are subject matter protection under Indian copyright law. But this is yet to be tested in the context of AI, and what needs to be seen is whether there's sufficient human contribution in such works or not, and this becomes the second pressure point. The third pressure point is the issue of safe harbor and intermediaries. And it is yet undecided in India. There's lack of, obviously, legislative clarity, as well as any judicial precedents that talk about whether AI programs would fall under the definition of intermediary or not. And if they do, there is, I'm afraid, a very onerous due diligence regime which intermediaries are required to undergo. There's also a mandatory takedown provision. In the latest set of amendments, just before I flew down from last week, there is a suggestion of imposing an additional obligation of watermarking, physical watermarking, not metadating, but physical watermarking of AI-generated works, which obligation has been put on the intermediaries again. So from the intermediaries perspective, if AI programs do get, AI service providers do get classified as intermediaries, they may allege over-regulation. From the right holder's perspective, it is lack of protection, and that's what the law is trying to balance, or should try to balance. The fourth pressure point is the fact that Indian courts are being faced with an increasing number of deepfake-related matters, so they're facing with enforcement of moral rights, of performers' rights, and more importantly, of personality rights, which so far remains uncodified in legislative form in India, and that's where much of the gray area lies, because anything to do with personality rights is judge-created, and there's no binding sort of precedent from the Supreme Court, the Federal Supreme Court of India, to that extent that sort of settles the position. So these are the four pressure points that exist. And my key takeaway from this would be that essentially, systems, legal systems in the global south, including in India, you can't call them anti-innovation. They're basically not AI-aware. And much of the pressure points are not a consequence of any express prohibition that exists in law, but it is more arising out of a lack of legislative clarity, and I think that's where the focus should be for the policy development.
Thank you so much for that whistle-stop tour and summary of all the pressure points. And I think, going back to the panel before, that is probably level one of the legal policy questions. Let me try and turn to level two. And really, while legal and policy gives the foundation, infrastructure is what's necessary so creators actually get paid. At the same time, we know that a lot of infrastructure in this space lags behind in the global south, and much of it is concentrated in the global north. To build a forward-looking copyright infrastructure for the AI era that means creators get paid everywhere, what elements do you see as essential?
I realize I'm out of time and Ari has signaled, so I'll try to summarize this in two key messages. I think what is important for the global south, considering countries like India, where we're looking at a 1.4 billion population, therefore 1.4 potential billion creators, as well as consumers, what is important is, you see, right holders cannot monetize what they cannot track. So while India, for instance, has had a completely digital copyright registry since many years, what it doesn't have is a digital registry or copyright registry having machine-readable rights. I think that's where much of the solution lies, at least from a rights holder perspective. So my two key messages on this point would be as follows. One, I think there should be regulation that mandates introduction of transparent machine-readable copyright registry databases, which should include mandatory use of metadata, unified metadata standards, also machine-readable licensing information instructions to see if a particular data set is licensed or not, what are the terms in which the license has been given, what can be done, and if there's a right holder that can be compensated, or a collective rights management organization that can be compensated, and so on. And third, of course, is linking to that interoperability with collective rights management organizations. That's only possible if the registries themselves, the regulators, maintain this data in that form. The second message or essential element would be to suggest a regulation that mandates data provenance and provenance in audit trails. So for the AI developers to function and keep training their models on data, I think what is most essential is that they maintain verifiable, auditable trails of where they picked up data from and what were essentially the permissions surrounding that data. And for this, again, some kind of watermarking or cryptographic embedding into that data set is essential for one to be sure, for enforcement, effective enforcement to take place, for also licensing to be efficiently put in place, And these are just two suggestions which I thought would be relevant for the second question that you asked.
Thank you so much. And Harry, I'm aware we would have lost the bet. We're late across the borderline. So with that, I just hope I have inspired all of us to further engage in cross-border and global dialogue, because at the end of the day, creativity, copyright, and AI development do not stop at national borders. And with that, I would like to thank you very much for being part of this panel discussion.
Thank you so much.